The Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel. Welcome to the Employment Roundtable, where we provide you with the perspectives and information you need to make wise employment decisions for your employees and your organizations. I'm your host, Talitha Ebrite, and today we're talking with my GableGotwals partner, Paula Williams, about non-compete and non-solicitation agreements. So Paula, why don't you start us off by giving us an overview of non-compete agreements and what restrictions apply?
Sure. Thanks, Talitha. So non-compete agreement is what we call a restrictive covenant in the legal world and a legal contract. And what it does is it says that a departing employee, whether they leave voluntarily or if they're fired, it says that they're not going to compete against their former employer for a period of time, and we need it to be limited to a certain geographic area. The reasonableness of the length of time and the scope of that geographic area is pretty fact specific. It's going to depend on facts like the industry and the employee's specific position, what they were involved with. Typically, I see that 1 to 2 years is a safe bet. They'll tell you, I've seen cases where, and I'm not just talking about Oklahoma, because we're going to talk about how non-competes are generally not valid in Oklahoma, but in other states, I've seen cases where 5 years is permissible. I've even seen a case where 15 years was permissible based on that specific industry that was at issue in that lawsuit. Same with the geographic area. The narrowness or the breadth of the geographic scope is going to depend on what's reasonable for that industry. Typically, you're going to look at where the employee was working and a geographic area surrounding that. So you can imagine that this gets complex in our world today, where you may have an Illinois employer with a remote employee in Tulsa who's marketing her business under the Illinois company's umbrella, but marketing herself to provide services to people in California, and wants to go work for a Nebraska company that also markets itself to people in California. Where's the geographic scope? It can get very hairy. In Oklahoma, our analysis is somewhat easier because in Oklahoma, absent some very small exceptions, well, they're big exceptions, but absent those exceptions, non-competes are generally not enforceable. That differs from, for example, our Texas neighbor, where non-competes are allowed. So you may also have an employer who operates in both states and has restrictive covenant agreements that look different, where one may include a non-compete in Texas, but in Oklahoma, it's more confined to the non-solicitation provisions that are allowed in Oklahoma.
Thanks, Paula. Now, so you just sort of gave us the overview that, in Oklahoma, these types of restrictive covenants are generally not enforceable, but you hinted that there might be some exceptions. So what sort of options in this area do Oklahoma companies have?
Yeah, the main exception that we see is when there's a sale of business. So when there are partners and a partner departs and the remaining partners stay in the business, then we can prevent that departing partner, the partnership, from competing through non-compete. In a sale of a business, even regardless of partnership, let's say we have a company that sells the company, including the goodwill, to a second company. That purchasing company is going to want to make sure that the departing leadership and the departing salespeople don't just reopen as XYZ Corp, take all their same clients back, depriving the purchaser of what they really bought, the business, its clients, its revenue. So sale of a business, departing partners, those are the primary exceptions we see in Oklahoma where you can actually have a non-compete provision. It still needs to be narrowly tailored with time restrictions and geographic restrictions. The geographic restrictions are in Oklahoma statutes. But in Oklahoma, that's the primary exception that we see.
Well, now, so I think it'd be a little bit helpful to sort of understand, if these types of restrictive covenants are permissible in other cases, what is the justification in Oklahoma for saying that you just can't do them here?
Sure. So in Oklahoma, it's seen as first anti-competitive. So there's a thought that we want to incentivize competition among employers. We want to incentivize people to get paid more by a competitor. It can affect wages if people can't go work for a competitor. It limits an employee's right to work and freedom to work if they leave one industry and they're completely unable to work in that industry going further.
Okay, thanks. And, we often talk about non-compete and non-solicitation agreements or provisions in the same breath. What are the differences between those types of agreements or provisions?
Sure. So a non-solicitation agreement is valid in Oklahoma and other states as well. And I'm using Oklahoma because it's where I primarily practice, but it still has to be pretty narrowly tailored. So in Oklahoma, you can have a non-solicitation one of two ways. The first way is a preventing a departing employee from soliciting your clients or your customers. This is limited to direct solicitation. So calling former customer up on the phone, "Hey, John, I'm moving companies. I'd like you to come buy your widgets from me at my new company XYZ. That's direct solicitation. So in an employment agreement or a separation agreement, any employment contract, the employer can have the departing employee agree to a non-solicitation that says they will not directly solicit established customers. What that means is we can't cast so broad of a net that any customer that the company has ever done business with, any person who's ever inquired or received a bid, they can't automatically fall under the umbrella. We have some good language from a Court of Civil Appeals opinion that's quoting Oklahoma Supreme Court decision that was ultimately reversed, but we still have this great language that really explains what is meant by that statute. And the court said that it means there's a relationship that was ongoing and anticipated to continue into the future when the employee left. If a customer falls under that definition, then we can prevent that departing employee from soliciting them to their new workplace. We cannot prevent general advertising or indirect solicitation, like announcing on LinkedIn where you're headed next. The second way we can prevent solicitation in Oklahoma is preventing a departing employee from soliciting our current employees from the former employer. So employers can prohibit direct solicitation of their employees. This means a departing executive can't hire a recruiter to call, ring, 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 his best salesman and say, "Hey, John hired me. He really wants you to come work for his new company, XYZ." That would be indirect solicitation, and we can prevent that as well in these non-solicitation agreements.
Great. And so it sounds like, these are good ways for employers to protect their businesses, essentially. But what are some other ways that Oklahoma companies can protect themselves in conjunction with these types of non-solicitation agreements?
Sure. Well, especially in an industry that has confidential information, trade secrets, pricing structures, vendor relationships with vendor pricing, you name it. If it's confidential, we want to make sure it's protected. We like to have a separate, robust confidentiality agreement in place that we pair with a non-solicitation agreement. That way, if an employee does leave to compete, we can prevent them from taking our established customers. We can prevent them from taking our employees, and we can prevent them from using the confidential information that they gained while they were at the workplace to compete. So again, sales information, pricing structure, customer lists. And I'll tell you that sometimes, even if they don't have that information in a file on their computer, sometimes we can still make the argument that they will inevitably be using that information in their new position, especially if it's the exact same as their old position, because they know who the customers were. They know who the contacts were. They know who the vendor relationships were with. They know how much the pricing was for services that were being offered. So we also like to have companies, in addition to the robust confidentiality agreement, be really clear with incoming hires about whether or not those new employees have existing obligations under a restrictive covenant. As the new employer, you want to know if that employee is under a non-solicitation or a non-compete. Again, if it's one of the situations that's valid in Oklahoma or in another state, if it's appropriately limited, you want to know that so that you as a company can say, you need to abide by that. We are not asking you to solicit employees. We are not asking you to solicit customers. You must abide by that. The company may even provide contact information like HR. If one of your former coworkers approaches you, make sure that you direct them to this person. We do not want you to solicit that employee. That helps protect the company from a conspiracy claim, from a tortious interference with contract claim. When they get looped into the breach of that contract, if the employee is perceived to be breaching that agreement for the benefit of their new employer.
That makes a lot of sense. Smart advice. So, my understanding is that there are some recent indications that the Federal Trade Commission might be, taking a hard look at non-compete agreements and potentially even banning them. What's the latest news about those efforts?
Sure. So the FTC has proposed a rule that would ban employers from imposing non-competes. Now, again, in Oklahoma, we don't have those except those limited scenarios already discussed, but they are certainly present in other states. The FTC rule would also require employers to rescind currently valid or pre-existing non-compete agreements. So it would be a major change.
Okay, great. And so, I assume the rationale is the same thing that we discussed about, why Oklahoma doesn't allow them, just sort of prohibiting employees' rights to work.
Right.
Is that pretty much what they're going with? Okay.
Yep.
Now, what stage is the FTC in that rulemaking process?
We're a ways out. So the FTC isn't expected to vote on a final version of a rule. So when a federal agency is making a rule, there's a long process where they're providing notices, they're receiving public comment, they're discussing it, they have another version of the rule. They're expected to vote on a final version of the rule next spring. I recently read April 2024. So we are 9 months away from even a vote on the final rule. If it passes, there will undoubtedly be litigation questioning the validity of that rule. Many organizations and people believe that that kind of rule exceeds the scope of what the Federal Trade Commission's power is. So it's unlikely to take effect for a while. When those kinds of rules are challenged in federal court, you will typically see a federal judge put a stay on the enforcement of that rule while everyone's figuring out if it's valid. So we're unlikely to see a change for a while. But what's important to know is that confidentiality agreements, like I discussed, and non-solicitation agreements would not be affected. So employers can go ahead and implement those and work on those in Oklahoma without concern that if this FTC rule passes, it would affect those.
That's really important information. Thank you so much, Paula. And, thanks for the benefit of your experience and for explaining those types of agreements to us. It was particularly interesting for me to hear about, just the different types of solicitation that we're thinking about in those non-solicitation agreements, and how employers want to protect themselves, both in terms of employees who might be leaving them, but also in terms of employees who they might be onboarding. So I think that was really useful. So thank you for that. And thank you for listening to this second season of the Employment Roundtable. We look forward to connecting with you next season and providing you with more information you need to make wise employment decisions for your organization and your employees. Thank you. The Employment Roundtable podcast is produced by the GableGotwals law firm. The Employment Roundtable is provided for educational and informational purposes only and does not contain legal advice or create an attorney-client relationship. The information provided should not be taken as an indication of future legal results. Any information provided should not be acted upon without consulting legal counsel.